I will now call the case of State v. Miles. Mr. Shire, when you're ready, you may.
May it please the court. Mr. Shire, again appearing on behalf of the defendant appellant, Jeremy Miles. It's my intention today to cover issues 1 and 2 of the briefs. I don't anticipate getting past those issues. If this court has any questions about the case that I am not addressing in argument, please do not hesitate to redirect my presentation. So moving to issue 1, we have conceded instructional error here. At trial, Jeremy stood charged of first-degree premeditated murder. During a jury instruction conference, the district court determined that it was both legally and factually appropriate to instruct on the lesser charge of intentional second-degree murder. However, when the time came to actually instruct the jury, the district court inadvertently, it seems, neglected to provide an elements instruction on the lesser of intentional second-degree murder. Without that elements instruction, Jeremy's jury had no principled way of ascertaining whether he was guilty of the greater or lesser charge in this case. As I read the state's brief, they are putting all of their eggs in the basket of contending that the error in this case was not clearly erroneous. But in my view, that is not this court's reversibility standard. First and foremost, we have a requested instruction in this case. And that, I believe, puts us in the territory of reviewing for harmless error. Furthermore, I think even if this court views the instructional error in this case as unpreserved, we still have a violation of my client's Section 5 right to a jury trial. I don't believe that the state contests that point in its briefing. And in State v. Gleason, this court held pretty clearly that Section 5 violations are not subject to clear error review anymore. When a jury instruction results in a violation of a criminal defendant's state constitutional right to a jury trial, that error is presumed prejudicial whether there's a trial objection or whether there is not a trial objection. So the real question before this court, in my view, is not whether it is firmly convinced that the jury would have returned the verdict that it did, but for instructional error. The question is whether this court can be confident beyond a reasonable doubt that instructional error had no effect on the jury's verdict. And given the evidence in this case,
I just want to be clear. So you're saying that once a defendant requests an instruction, even if the defendant is shown a set of the instructions that are about to be given and is asked whether there's any problems with that set and says nothing, there's a Section 5 problem?
in addition to our contention that this is preserved as instructional error.
Right.
Yes, Your Honor.
Okay.
And I think that's pretty clear. If this court looks at its case law, it clearly illustrates that defendants at common law, when Kansas's Constitution came into existence, had a right to a jury trial on lesser included offenses if a judge decided that it was legally and factually appropriate to instruct on a lesser. And that's what we have in this case. The judge clearly ruled that it was legally and factually appropriate to instruct on the lesser, but the jury was not given an opportunity to convict on that lesser due to the non-provision of the elements instruction. So that puts us in the area of constitutional harmless error review. I don't believe that the state's error, that the state can meet that burden, because the evidence of premeditation in this case was quite weak. We have homicidal acts that occurred within a brief span of 15 seconds. We have no apparent motive for a premeditated killing. We have no direct evidence of premeditation. We have basically a vacuum of evidence that permitted jurors nothing more than a guess as to what was going on in the mind of a perpetrator prior to intentional acts that resulted in death. It is not at all clear that a properly instructed jury would have convicted on first-degree premeditated murder. And based on that, we would respectfully ask this court to remand this case for a new trial. I would also note, even that if this court were to agree with the state's contention that we are in the territory of clear error, it's still my view that Mr. Miles is entitled to a new trial for two reasons. First, I think we have met the traditional clear error burden. Given the weakness of the state's evidence of premeditation, I believe this court should be firmly convinced of a real possibility that a properly instructed jury would have returned a different verdict. Additionally, as a noveler argument, I would contend for reasons outlined in our briefs that an appellant's showing of clear error should not turn on prejudice. And my reason for making that argument is KSA 22-34-14-3's plain language. The plain language of that statute permits reviewing courts to assign error to jury instructions that are, quote, clearly erroneous. The plain language of the statute does not permit assignment of error to clearly prejudicial instructional errors. The error in this case was obvious. The state concedes it in its brief. I don't think that anybody could plausibly contend that the district court was right not to instruct on a verdict option offense. Because the error is obvious, it should be reviewable pursuant to the plain language of statute. And I concede that our advocated interpretation of KSA 22-34-14-3 is at odds with this court's longstanding precedent. But recently in State versus Waldschmidt, this court noted that unreasoned judicial repetition should not inform this court's interpretation of KSA 22-34-14. This court noted in its State versus Williams case that its clear error reversibility standard really isn't tied to the plain language of statute and is at odds with the conception of clear error that Kansas courts employed prior to the enactment of KSA 22-34-14. At common law, the common law that KSA 22-34-14 was intended to codify, clear error meant error that was obvious, not error that was obviously prejudicial. This is all outlined in this court's Williams opinion. And for that reason, I would contend that even if we do get to clear error, which I don't think we get to in this case, we still have reversible error. Unless this court has any questions on the instructional issue,
I ask you to briefly summarize your constitutional claim with respect to the law as it existed in 1859.
Yes, Your Honor.
On lessers, essentially.
On lessers. So I think if this court looks at its own case law, it supports two notions. Number one, the judge of a trial got to decide on whether to give lesser included offense instructions. But number two, as a corollary to that, if a judge decided that it was legally and factually appropriate to instruct on lessers, that had to go to a jury, and a defendant had a common law right to jury fact finding on that matter.
And can you give me what cases are you relying on for that?
Berberich.
Or you can even just point me in your brief to.
Now, as far as cases that have dealt with this precise issue, I don't believe that there are any because this is a novel issue. Okay. But the understanding of common law is set out in the Berberich opinion. That's from 1991. State v. Love, I think, illustrates the idea that judges decided on whether to give lesser included instructions, but that the right to jury trial existed if the judge made that.
Would it be correct to summarize your argument to be that you don't have case law from the 1860s that you're relying on here? you're relying on modern day cases that
Well,
about a common law.
I'm relying on modern day cases that recite what common law was at the time. I would also rely on the Beck opinion. That's a United States Supreme Court opinion that is summarizing common law, obviously at an earlier point in American history.
So I appreciate that. And my follow-up would be, this is an odd case because it's not a case where no lesser instruction was given. I mean, the jury was presented with the lesser included of second degree intentional, but the elements were not provided. So how should we, I just wanted you to articulate how you think we should think about that. It's not as though the jury couldn't have returned a verdict of second degree intentional, right? The instruction said they could.
Well, it was on the verdict form, so I suppose the jury had the raw power to do that. My view, though, is that there was no principled way of exercising that raw power without understanding.
And that goes to, there's another test that we sometimes apply to instructional error claims, which is, was it confusing to the jury? And I'm just wondering why that might not be the appropriate test here, given that not only was it on the form, but in the actual instruction, you have the elements instruction on premeditation, and the instruction immediately following says, this crime includes the lesser of second degree intentional, and you can convict of either premeditation, second degree intentional, or acquit. Isn't that what the instruction says?
Well, Your Honor, I think it goes beyond just confusing. Although even if this court decided that the only problem with the set of instructions in this case was that it was confusing, I still think we get to reversible error. But I think it goes beyond that because, you know, without an elements instruction, there is just no principled way that a jury can make this decision. There's no way that a jury can say this was an intentional murder without knowing what second degree intentional murder is. It's functionally the same thing as not instructing at all, is my view. And that's probably my best answer to your question.
There was many times in lesser included cases, there's kind of a sequential consideration, for lack of a better way to put it, in the instruction package itself. I'll paraphrase. This is something, if you cannot agree the defendant is guilty as charged in, you know, first degree murder, then you shall consider the lesser included. That sequential type of consideration isn't in this package as I am reading it. Is that correct?
My recollection, Your Honor, is that there is instruction that the jury can convict on intentional if they did not reach a unanimous verdict on first degree premeditated. And I believe, I'm going off the top of my head. I may be
just looking at instruction number 9, and I was, maybe there's others.
off the top of my head. I believe it might be instruction 11, Your Honor. I don't have the record in front of me.
Yeah. Anyway.
Well,
typically
that would
there's
certainly compound.
Yeah. Typically, there's a kind of a sequential consideration because my question basically goes to, they did convict as charged of premeditated, first degree premeditated. But it appears that the way the jury was instructed to consider that is they're to consider that together with second degree as opposed to independently of one another. Is that right? Well, it includes the charge of intentional second degree murder. And you make, anyway, I noticed the absence of it.
That's certainly significant, Your Honor, and that just reinforces our position that this is prejudicial reversible error.
Okay.
I see I've gone over my time limit. As far as the prosecutorial error claim, I would just note that to me, that seems like pretty clear-cut error pursuant to this court's case law. And that would also independently require a new trial. We would respectfully ask this court to reverse and remand for a new trial on the basis of instructional error, on the basis of prosecutorial error, or on the cumulative effect of those two errors together.
Any other questions? Thank you, Mr. Shire. Mr. Maloney.
Thank you, Your Honor. May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. I'm going to start at the end there because it's fresh in my mind, where counsel argues that it was pretty clear that there was prosecutorial error in discussing premeditation. And I strongly disagree with that. I think when you read the prosecutor's closing, both prosecutors' closings in their entirety, in context, as we always have to do, you see a very accurate description of premeditation. This was not something where either prosecutor ever said that premeditation can be formed in an instant, which is essentially the argument that the defense has made. The prosecutors here walked through evidence starting from well before the killing. Pointed out the fact that he made this statement to the young man in this car about, have you ever shot a gun, while they were still on the way to the victim's apartment. And then mentions the fact that when they get to the apartment, the young man saw the defendant with his arm raised, extending the gun, pointing at the victim, and argued that that was further evidence of premeditation formed before even firing the first shot. And then the prosecutors pointed to the evidence about the number of shots that were fired. There is nowhere in there. Now, the comment that she made in the initial portion of closing argument that the defendant really is focused on is each trigger pull is another act of premeditation on the part of Jeremy Miles. Now, again, if you divorce that from all of its surrounding context, that might seem problematic. But right before that, literally the sentence before that, she says, it's not just one shot, it's not just two shots, it is 12 distinct shots. And this court's case law talks about the fact that the number of shots, the amount of time that the act takes, are certainly factors that can factor into premeditation. And I set forth the evidence in the brief. It's not just the number of shots, but it's the sequence. There's a shot, and then you can hear this on the audio recording. There's then a pause. Then there's a sequence of 4 more shots, another pause, and then a sequence of the final 7 shots. All told, it took about 15 seconds. The physical evidence shows that there were shots fired at the couch, which is where the victim was initially seated. The evidence shows that the victim obviously did not die instantly because he was able to crawl from the couch several feet across the floor. And then you see the bullets essentially followed him. And so all of that, the sequence, the number of shots, the pauses in the shooting, 2 pauses in the shooting, those are all absolutely factors that the prosecutor rightfully pointed to. And not only did she not say that premeditation can be formed in an instant, at the start of her argument, she expressly said the opposite. She first of all, she pointed to the instruction and directed the jury's attention to that. But then she also said that it requires more than something to be formed in the instant. And so our position is very much that there was not only not obvious and clear prosecutorial misstatement or error, but there was no misstatement at all. When you look at those comments, everything that they said, both in the initial and rebuttal closing, was appropriate. Now addressing issue 1, and without question, the district court made a mistake in this case. It's clear from that initial instruction conference that not only the district court, but that both parties agreed that a lesser on intentional second degree was warranted. The court planned to give that. I think when you look at the record, it actually is pretty clear why this error happened or how it came about. There were a lot of revisions to the instructions in this case. And on that Friday, it's pretty clear that the judge's assistant, I think everybody had initially, she thought that they had reached the final decisions on the instructions, and she was surprised that they were going to have to go back and tailor them even more. And she made the comment that she would come in over the weekend if necessary. And then the judge stepped up and said, no, don't worry about that. I'll do it myself. And so this is the rare case where the judge himself is the one who actually drafted the final written instructions. We come in on Monday. The court says up front, I have handed both parties a copy of the new instructions. And we know he did because the state pointed out a separate mistake in a different instruction. So we know for a fact, I think one of the arguments that the defense made in their brief is that the defense attorney really didn't have a chance to address the mistake that occurred between the time that he filed the proposed instructions and what occurred. But we know that's not true because this, again, the state did point out a mistake. So the defense doesn't catch it, and to be fair, neither did the prosecution, and obviously the court didn't either. But I think that's kind of the genesis of why this occurred. But in any event, then the end result is that the defense was given an opportunity, did not object to that instruction that was issued. So there was an instruction. I know that counsel has argued that functionally this is the equivalent to not instructing at all, not giving the lesser. But I would disagree because clearly that instruction does tell the jurors that they have the option of convicting him of the charged offense or the lesser offense. Undoubtedly, the instruction then fails to contain the elements. Our position with respect to harmlessness is that, and I pointed this out in the brief, ironically, the fact that the instruction completely omits the element, I would argue, makes this more likely to be harmless than if the instruction had simply omitted one element or two elements out of a several element instruction. Because if there's an instruction, if there's an element instruction or a crime that, let's say, includes 4 elements, and the court gives an instruction and it includes 2 or 3 of the elements, then the jurors are simply going to have no way or no reason to know that the instruction is somehow inadequate. Unless there's a jury full of legal scholars who know all of the elements of every crime in Kansas, they're not going to know whether an instruction that contains 3 elements should actually have contained 4 or 5. But here, you don't have to be a legal scholar to look at it and see, the court just told us that we can convict him of this lesser offense that's called intentional second-degree murder. But unlike all of the other crimes that are charged in this case, the court doesn't give us any guidance whatsoever on what that means. So I think clearly the jury, anybody with common sense would have been aware that there was something lacking. And that's where I think the fact that the jury never asked a question about that would pretty strongly indicate that they never really got to the second degree because they were unanimous on the premeditated.
There was no, many times in lesser included offense instructions includes an instruction on how to consider the lessers. And that I don't see that in the package. That's what I was trying to point out to Mr. Shire, is that typically you consider the first, and if you can't agree, then you go to the next less. I'm paraphrasing.
Right.
And am I right? Typically, Mr. Mahoney, that's typically a part of the package. It's not here.
Yes, I believe you are right, Your Honor. The only thing that I cited in my brief.
With that, I think you could then make the argument, well, they did what they were instructed to do. First considered, were unanimous. There's no need to go on to the lesser. But that isn't what the instruction says. I mean, the instruction says you shall consider both, essentially, is what it says. And how do you consider both? You're not fully understanding of what you're supposed to compare them to or consider. That's where I'm stuck.
Right. And I definitely agree that my argument would be even stronger if it did have the sequential language in there. But I still think that the fact that the instruction is just so wholly inadequate as far as omitting any elements of it, I think it's hard for me to think that there's any reality in which a jury would see that error, realize that, hey, there's nothing here to guide us. And if they had any question in their mind about the premeditation or whether this was just second degree intentional, that they then wouldn't call it to the court's attention and say, and ask a question and say, Judge, we noticed that there's no elements in here. What is that? Or Judge, we are uncertain right now and we would like some guidance on this issue. And so I think, and also the fact that the prosecutor did discuss this in her closing argument and basically said, look, you've got the instruction on premeditation. We also have this lesser of second degree intentional. Two of the three elements are the same. So essentially letting the jurors know that as the title of the charge of defense would indicate, that the only difference between the two is the absence of premeditation from the intentional second. And of course, the defense didn't challenge the prosecutor's statement because it was accurate. Perhaps if it had been something, I know obviously that the statements or arguments of an attorney are not the same as if there had been an actual instruction. And I'm not saying that they should be entitled to the same weight. But where the prosecutor makes an uncontroverted statement about something as simple as, hey, the difference between the charged defense and the lesser is that you've got this one missing element, this one element that is absent from the lesser. The defense doesn't contest that because there's no reason to. The jury then never asks a question about what the elements are. I think that when you start adding all of these things together, you have a very strong argument that there simply was not a doubt in the juror's mind as to premeditation. And then you add in the way that this case was presented. This was not a case, frankly, where, now clearly, the parties and the court had all agreed that the court was going to instruct on the lesser of intentional. And I think, going back to the first argument today, based on this court's case law, I think that would have been obviously what guided their decision to go ahead and give that. But this was not a case where premeditation was the focus of the defense at all. The defense's position was clear. Jeremy Miles had no role in this killing, and in fact, did not even go to the victim's apartment that day. Now, of course, the jury is always free to decide as they see fit. But when you have a case where the defense is saying flat out, I had nothing to do with this killing. I wasn't even near the crime scene. That further adds to our harmless error argument. And then the overwhelming evidence of premeditation. This is a case, one of the rare cases. Now, it doesn't rise to the level of the previous case where he literally said, I'm going to shoot this guy in the head. But it's somewhat close in the fact that as he's driving over to the apartment, he says to his wife's brother, have you ever shot a gun before? He then goes into the apartment. He fires 12 shots at an unarmed man over 15 seconds as the victim tries to crawl away. And then when he gets back to the vehicle after the killing, he makes another statement about how he's on a killing spree. So this is incredibly strong evidence of premeditation, very rare, I would say. Usually we do have to prove premeditation more circumstantially, but here we have very strong direct evidence of premeditation. And then you have a defense that doesn't even remotely try to focus on premeditation. This isn't something where they made an alternative argument and said, our position is that my client was not there, but even if you disagree and you think otherwise, there's no indication that he thought this over beforehand, that it was just a spontaneous act, that something happened in that apartment or that he was provoked. There simply is none of that. So I think, again, no question that there was a mistake made here, and I'm sure that the district court would be the first to acknowledge that. And obviously the state is acknowledging that throughout this appeal. But when you look at all of these factors, I just have a hard time seeing a case where there would be a stronger argument that this error was in fact harmless. And so our position is that this mistake, while unfortunate, did not affect the outcome of trial under any standard that this court chooses to utilize in weighing that. And again, just to summarize my position on the second issue, I think that the prosecutors did an excellent job in this case of accurately pointing to the factors that this court has authorized in the concept of premeditation. And so our position is that there was no error beyond the instructional error in this case. And we would respectfully ask that the defendant's convictions be affirmed.
Can you briefly recite your position with respect to the constitutional claim, the Section 5 claim?
I don't know that I necessarily have a great amount to add to that, other than the fact that Gleason does talk about the fact that, even under that standard, the presumption of prejudice can be overcome. And in that case, they essentially looked to the strength of the evidence.
Well, do you agree that we ought to apply? I mean, is Section 5 implicated here?
I think under, and I was just refreshing my recollection on Gleason as counsel was arguing, I think that if you continue to apply Gleason, I do acknowledge that there would be support for his argument there, that would seem to be because, in Gleason, there was the missing element. This case is a little different because, as I pointed out, just the way that the error came about and the fact that it's wholly missing any of the elements instead of just omitting a particular element. But I do think that I would certainly be open, and I would assert that it would be appropriate for you to reconsider whether Gleason was correctly decided, because I do think that in a situation like this, that clear error should still be appropriate given the way that this came about. But ultimately, my position is that even under Gleason, just like in Gleason itself, that the error was harmless.
Any other questions, colleagues? Thank you.
Thank you, Your Honors.
Mr. Shire, you reserve 3 minutes.
Thank you, Your Honor. I'd like to make a brief point on harmless error and then cut to the prosecutorial error claim. As I understand the state's harmless error argument, it's essentially that trial evidence was overwhelming because of the testimony and statements of Kareem Hendricks. Well, a jury may not have decided that Kareem Hendricks's testimony was reliable. A jury may not have decided that his statements to police were reliable. It was the defense at trial that those statements and that testimony was not reliable. So I don't think when conducting harmless error review that this court can assume that the testimony of this particular witness is something that a jury would have given credit to. With regard to prosecutorial error.
What about I'm sorry to interrupt you, but the other argument about the, once inside the apartment, the physical evidence and what you can hear on the ring, a series of shots, pause, another series of shots, pause, and the final sort of series of shots, evidence that the defendant was moving in the process. I want to incorporate that into your harmlessness argument.
Absolutely. So that evidence, we're talking about a pause of seconds. These are 12 shots fired in the course of 15 seconds. That's approximately 1 shot a second. I think that is not overwhelming evidence of premeditation. I think somebody can be acting on impulse for a period of 15 seconds. And I think a jury may easily have found that. That does cut neatly to the prosecutorial error claim. The prosecutor here argued, quote, each trigger pull is, quote, another act of premeditation. The prosecutor did not argue that you could infer premeditation from the number of shots. The prosecutor argued that each trigger pull was in itself an act of premeditation. That conflicts with Morton, where this court found reversible error when a prosecutor argued a squeeze of a trigger is all it takes for premeditation. It contrasts with Hall, where this court found that a prosecutor erred by saying that premeditation could be formed within 4 rapidly fired gunshots. It contrasts with I believe, no, I don't have the other case in front of me, but it simply is not in line with this court's case law. And the other problem with the argument is that there is no evidence whatsoever as to which of these 12 gunshots may have independently caused death. After there is an act that independently causes death, we have a line of demarcation. No premeditation can occur after that point. If the first gunshot in this case would have independently caused death, then there could be, as a matter of law, no premeditation after that point. So that provides another reason why the prosecutor's argument is a misstatement of law.
Any
Unless-
other questions? Mr. Shire, thank you very much for your arguments. Court will take this matter under advisement.